fourth theme. In fact, Professor Manoj sent me second theme, and when I was preparing, then again he sent me its fourth theme, where you have to prepare on constitutional mandate and working condition in the era of neo-liberalization. Then I was just telling Manoj sir that when I become chairman, don't invite for any lectures, because again we have to start preparing things for seminar and all. Since it is our domain, somehow we should connect constitution with that labor related legislation. I was happily agreed to share my views on the constitutional mandate and working condition in the era of neo-liberalization. As you all know, Constitution is a sacred document, and it is a basic fundamental political document of our nation. Whatever legislation we pass, generally either in center or state, they should be in accordance with the constitutional mandate. And especially when it labor issues comes, I keep telling wherever I go, before we go to bed, we should remember four people in the nation. Number one, I keep telling that framers of our Indian Constitution, because they labored such a way to draft a beautiful constitution to the country where diversity matters. Since 1952 till it is working, in the sense it is a miracle. In fact, I requested Manoj sir to share the videos of yesterday's lecture. I got through all lectures. Then Professor S. Patil sir was mentioning that Rajiv Dhawan, who wrote a book on Constitution of India, The Miracle, Surrender and Hopes. And if you want to know the importance of our Constitution, one shall be sent to Afghanistan. If you go to Afghanistan, you will come to know the importance of our Constitution. Similarly, second one, farmers of the nation. Framers, farmers, there is a confusion. Farmers, they are the backbone of our nation. Then third one, soldiers, they protect us. You will have sound sleep at home because of our soldiers. But nobody knows the importance of laborers. Importance of labor comes into picture during COVID-19. Even Dhirubhai Ambani groups, he may be rich, but when COVID-19 issue comes into picture, no one wants to go and work in their respective places, because of everyone wants to lead their life without any issues. So considering that, we have series of legislation to protect, promote and preserve the rights of working classes. Now thing is how to reconcile the present legislation with the constitutional mandate when it comes to the neo-liberalism issues. Nowadays, you come to know all public sectors are becoming like private sectors. They are privatizing all the government sectors, and wherever you go, I just whenever I teach constitution, I keep telling my students that one East India Company, advent of East India Company, they ruled us for 3 centuries. Be prepared to be ruled by today's MNCs companies. To 2050, all will become slaves to MNCs, because they don't care for the Granna, what you call Constitution of India. If you just go through the practice, theory is different, practice is another thing. When you just go through so many legislations, in fact, to protect the interest of working class, we have series of legislation like Factories Act, Industrial Dispute Act, then Equal Remuneration Act 1976, then Contract Labours Act, Contract Labour Regulations Act. Like there are series, now they have introduced new 4 labor codes to ensure the rights of laborers. But now what we have to introspect, the level of implementation. Wherever I go, we have maximum, we have maximum laws with minimum implementation. According to my sense, there is no difference between 2 statements. A state without law, one side, another side, state with law without implementation. There is no difference between these two statements. Better not to have laws when there is no scope for implementation. And even in Constitution, I think yesterday Professor C.S. Patil sir also highlighted the judge and all other resource persons. They have highlighted whenever we want to discuss any vulnerable sections of the society, including labor, we always get into Article 21 of the Constitution. And very particularly when you come to direct state policy, 38, 39, 41, sorry, 42, 43, like these are the very important article which protect the interest, not only which not only protect the interest of labor class, it protects the interest of vulnerable sections of the society. Here, I wanted to take up in the fourth theme, I wanted to work on, speak something about the working hours of laborers, where we have to go through some important statistics. I cannot decide how many hours a labor or workman employee should work in their workplace. I can just tell about the Supreme Court verdict or the existing legislation or international conventions, whatever laws, conventions, Supreme Court directions or policies we can mention. But who has to tell? The experts. When I just go through this morning, I come to know some of the statistics according to some research, and which is available in the government website, where India is a home to 522 million workers, which is set to increase up to 570 million by 2030. Many occupations in India require longer working hours, for which many times the workers are not paid for the overtime, and even it's a culture in many unorganized sectors to work for 12 hours or even 14-hour shift. These increased working hours can cause many health impact on workers, causing many addictions and chronic diseases because of this work environment. Long working hours can negatively impact an individual's physical as well as mental health, increasing the risk of cardiovascular disease, mental health issues, and reduced productivity. In fact, this is the paper written by some of the doctors. It's a joint article where they have mentioned with the statistics, in case if they work more than specific hour, what will be the issue. And according to research, 86% men and 67% women are working more than 40 hours per week, whether they are paid or not for the overtime. The effect of working too much can be felt both personally as well as professionally. Now let us discuss what is the working hours where in Indian perspective, what are the observations, what is there in other countries, and how to overcome. What is the role of Indian judiciary in this regard? In case if it exceeds, something goes wrong in the private sectors. We say we have legislation like Industrial Dispute Act, Practice Act. Now we have labor codes and yet to be enforced. We keep telling that there are labor laws are there, labor codes are there. We can go and get remedy from these competent courts. But in reality, access to court is not a easy task. I always make fun. Under Article 32, Dr. B.R. Ambedkar said, it's an heart and soul of our Indian Constitution. But this heart and soul beats for whom? A Ramaya or Rangaka, Rajamma from Taluku, local village, forget about going to Supreme Court. They cannot move to the Taluk courts. I don't know how 32 will be enforced. Of course, we have a right. I can file a writ petition direct. Now, if you go through constitutional landmark judgment, no Rangamma, Rajanna, Rajappa filed a petition before Supreme Court or High Court. Forget about even Supreme Court. Even they cannot approach even High Court. Who are there? Only Shankari Prasad, Sajjan Singh, Golaknath, Keshwananda Bharat. It beats only for elite classes. When such being the case, when you have a legislation, when you have a Supreme Court direction, who cares for it? Who has to come forward? In that respect, how NGO can play a significant role. For example, now because Article 21, there are so many unenumerated rights for evolved, like right to livelihood, right to live with dignity, right to food, that right to shelter, everything. Everything comes because of some NGOs' participation in the democratic setup. If PUCL or PUDR or Vishaka, like these voluntary organizations, if they have not come forward to file writ petition before Supreme Court, you would have not seen all these unenumerated rights were in Article 21. Because of their participation in the democratic process by filing writ petition before Constitutional Court, today many rights are protected to some extent. When such being the case, here I wanted to refer even the statement made by the best, people who achieved in corporate sector, Narayan Murthy from Infosys and Subramaniam from the L&T, where they mentioned that today's hustle culture only makes things more competitive, where we have tech, giants like Mr. Narayan Murthy of Infosys stating 70 hours work week should be the norm. And L&T chairman says, expressing regret that Sundays are not a mandated work day and all should work 90 hours a week. There was once a time where people used to work for 16 or more hours a day. But in May 1st, Labor Day, was the moment advocating balanced allocation of time, that 8 hours for work, 8 hours for rest, and 8 hours for recreation, ensuring a person had a work-life balance. Working hour, work-life balance, and one more important concept, right to that is developed in France, some of the countries where right to disconnect. This is a right. This is a right of laborers in other countries. Forget about disconnect. Here, if they allow just work even for 8 to 10 hours, that's a great thing. If you allow the laborers to work more than 8 hours, 10 hours, what will be the consequence? We keep telling that when we work somewhere, for example, drives in the night, something goes wrong, that occupational disease in future, who is responsible? Again, you have to go to the court. Again, you have to go to the labor court or constitutional court. Who is going to take care of it? And somewhere we have to, now recently, 3 days back, Karnataka government, I read in the newspaper, they changed the wages, the minimum wages. What should be the monthly salary of a particular, laborer and all. But when I was discussing with one of the industrialists, he was telling this is exorbitant. He says it is exorbitant. When you step into the shoes of industrialist, you never, endure, or you never consider the wages fixed by the state is reasonable. But when you are in the role of a laborer class, then you want more. How to balance? In that respect, what is the role of state also matters. State government, it is there in the directive principle of state policy. I always say, see, fundamental rights, it is our duty, it is our right that is available under Part 3. What about Part 4? Framers are very clever. Whichever rights do not have financial implications have been listed in the fundamental rights. Whichever rights have financial implication listed in the DPSC. DPSC, unfortunately, under Article 37, they are not enforced before the court of law. Again, connecting the directive principle of state policy with one O positive article called 21, it's like a universal donor. They connected the DPSC with Article 21 and they keep telling that these are the rights available, these are the rights. But now the issue is who has to implement it? What is just imagine if there is no role by NGO, what would have been the situation? And especially judiciary. Judiciary has played a very significant role. There are cases where they entertain public litigation. And one more thing, another issue is Article 12. You cannot bring private agency under the definition of Article 12 of the Constitution. If you just take it, if you just go through the neo-liberalism, in the era of neo-liberalism, if you don't bring private institute, private agencies or sector under the, because nowadays all public services are becoming privatized. They are privatizing all public services. Now there is no appointment faculty in any departments in any conventional universities. They are just hiring the contractual, faculty under based on contract. Guest faculties are there. And I was surprised to read, even I have some cases for maternity benefit leave also. I have written some articles where in some of the cases court held that leave sanction without pay or worker on the ground that was not regularly appointed was unjust and payment of maternity benefit was ordered. In some of the cases, court says the claim of lecturer appointed on an ad hoc basis for maternity leave was allowed. But if you go through our employees who are outsourced, whether they are P1 or trainees and all, even they are not entitled for 1 day leave in the month. University doesn't. It is in the mind. It is in our institutional arrangement in the sense. What about in the private institution? No maternity benefit leave, no leave, nothing. And where is the health facilities for that? We have Paramananda Katara's case, Consumer Research Center's case. Many cases are there where Supreme Court said it is the duty of state to provide qualitative healthcare service to the vulnerable sections of the society, where labor also included. Laborer also, workman, employee, whatever the nomenclature, they are all come under the purview of 21. Where is the question of implementation? So in that respect, India's working hours regulation is mainly drawn from the Practice Act 1948, restricting the working hours to 9 hours a day and 48 hours a week with the provisions for overtime. When it comes to the Contract Labor Regulation and Abolition Act 1970 governs working conditions for contract workers, but also doesn't have provisions relating to remote or hybrid work arrangements. This legislative loopholes is all the more relevant considering the increasing incidence of contract labor in the Indian economy, with contract workers having the potential for increased vulnerability in remote work setting due to limited mechanism of oversight. See, I'm not an expert in labor law, but I have read some good legislation, good piece of legislation. According to the Contract Labor Regulation and Abolition Act, if the type of nature of work is perennial type, where you cannot invoke this legislation. But there are cases where if you come to my university, they give just every year they will be now they have given to the agencies contract, because once if they started giving, if they continue their service every year, then again Umadevi case come into the picture. Then they want to be regularized. They want to be regularized. And Supreme Court and High Court, so many cases they directed the university, not only university, even private universities, private colleges, they should also pay very good scale to the employees, whether it may be faculty or non-teaching, whoever may be. Are we really observing? Is it come under the purview of Contract Labor Act? Again, it is contradictory to the legislation what they have passed. Then another legislation, Unorganized Workers Social Security Act 2008. Who knows? Faculty, law student like us, when we don't know about all this provision, how do we expect laborers know all these provisions? Workers, they know all these provisions. In this act, through enacting welfare scheme for workers in the unorganized sector, remains silent on working hours regulation and hence does not provide statutory protection to substantial part of the workforce concerning working time. Such regulatory lacuna is important since about 93% of Indian workers work in the unorganized sectors. Then, in this respect, the Apex Court in Bandhu Mukti Morcha versus Union of India clarified that reasonable working hours are a fundamental aspect of women working conditions under Article 21 and held that the right to live with human dignity enshrined in Article 21 derives its life breathed from the DPSP and particularly clauses like Class E and F of Article 39 read with Articles 41 and 42. This judicial approach has given constitutional protection against unreasonable working hours where there is no comprehensive legislation for dealing with new work arrangements. Further, Supreme Court in the case of Consumer Education and Research Center versus Union of India, broadening the ambit of Article 21 to encompass the right to health and medical care, ruling that the jurisprudence of personhood or philosophy of the right to life contemplated in Article 21 extends its reach to embrace human personality in its full bloom with the invigorated health which is health wealth to the workman to earn his livelihood. Such interpretation gives rise to the fact that regulation of working hours has to take into account workers' health implications, giving constitutional grounds for limitation of excessive working time. Then in the court further acknowledged the gender effect of working condition and it held that women workers need special protection in light of their dual roles in productive and reproductive spheres. This ruling gives constitutional basis to gender sensitive working time rules that are responsive to caregiving responsibilities. Further, in Delhi High Court, in the case MC Mehta versus Union was concerned with hazardous working conditions and overwork hours for child labor, confirming that working condition regulation has economic function but not just economic, as it aims to safeguard fundamental right to dignity and life. Although dealing specifically with child labor, this decision creates wider general principles concerning the state responsibility to regulate working conditions for at-risk worker categories. And one more. Now, this is these are the things are there in the previous legislation and including Supreme Court verdict. Now, the present among four courts, one of the courts that the Occupational Safety, Health and Working Condition Code 2020, part of recent labor code reform, consolidates 13 labor laws, including the Practice Act, introducing several modifications to working hours regulation, where Section 25 maintains the 48 hours work week limit, but allows appropriate government to exempt establishment from working hours provision, potentially enabling longer working hours through notification. Again, it is up to the discretion of the appropriate government to either increase or decrease. Then this deregulatory approach reflects neoliberal influence on labor regulation, prioritizing the employer flexibility over worker protections. The court's flexible approach to working hours potentially undermines the 8 hours workday norm established by the International Labour Organization's Hours of Work Convention. In the state of Punjab versus modern breweries, where the court recognized the relationship between work needs and personal life as a fundamental dimensions of workplace dignity and ruled that the dignity of the individual is a cardinal value not to be sacrificed in the interest of economic development. I repeat it, please listen. The dignity of individual is a cardinal value not to be sacrificed in the interest of economic development. Work-life balance forms an integral aspect of dignitarian conception. Such judicial recognition underlines the distance between constitutional values and statutory practices within India's neoliberal environment. Now, let us come to as we discussed here, 8 hours is the mandate. It should not cross more than 48 hours as per the existing legislation. What European Union, Australian frameworks, other countries have. Just I have listed out some few countries' rules and regulations with respect to working hours of the labours. Where in European approach, the EU Working Time Directive limits work to 48 hours weekly, including overtime, with mandatory rest periods. It applies to remote work requiring 11 consecutive hours daily rest and 24 hours weekly rest. The European Framework Agreement on Telework ensures teleworkers receive equal protection as office-based workers. Germany's and Spain national laws further strengthen these protections, with Spain explicitly regulating remote work, scheduling, and digital disconnection rights. Then when it comes to Australian perspective, Australia's Fair Work Act establishes a 38-hour standard work week with the provisions for reasonable additional hours based on factors including health, family, responsibilities, and compensation. Recent amendment address remote work challenges with the Fair Work Amendment Act 2023, introducing right to disconnect. Unfortunately, even we, the faculty professors, when we go to home, we never spend time with the family members. Still, we keep discussing about our profession. And you are not witnessed. The people who work from home, they are disturbed like anything. They cannot move. Even after that, boss will come, then their team will come in the midnight. I don't know for God's sake how it affects our health. It is very difficult to match the labor legislation to the constitutional aspiration. If you want labor legislation, forget about constitutional values. If you want to uphold the constitutional values, forget about labor legislation. This is what happening. See, just you go through meticulously. Australia 48 hours, sorry, European Union 48 hours, Australia reduced from 48 to 38 hours. When it comes to Asian regulatory approaches, Japan's labor laws limits work to 8 hours daily and 40 hours weekly, with 2019 reforms capping overtime. Japan's telework guidelines apply standard regulation to remote setting and recommend clear availability policies. Introduce 4 working days and has been significant increase in productivity and creative abilities. In India, if we introduce 4 working days, then Friday, Saturday, Sunday will be holiday, right? Then people start taking holiday one day before only. That is in the Wednesday only. Wednesday, see now Saturday is holiday. Then again they start having the mood of Friday only the holiday. Where in the government sector, I'm telling you. But when it comes to the private sector, there is no all these privileges they enjoy. Then when it comes to North America framework, the U.S. Fair Labor Standards Act establishes a 40 hours work week with overtime requirements. Some states offer stronger protections with emerging right to disconnect. Once if they leave the employment place, again either boss or their work team, they should not connect them. That is disconnected. Right to disconnect in turn helps to ensure qualitative life in their personal life. Then in New York and California, then Canada's approach varies by province, with Ontario limiting work hours to 48 hours weekly and Quebec requiring employees to develop disconnect policies. Then let us make a comparative analysis. The comparison with India's model and international framework is really dramatic. While India has a heavy reliance on conventional labor law inapplicable to modern work arrangement, jurisdictions such as EU, Australia, and Quebec have built systematic framework responsive to remote work environment. Some of the salient differences that arises are, I have some points. Before that, of course, what is there in other countries, we need not to adapt, but we should not increase because when I teach my students, I keep telling that India cannot be compared with any other nation in the world for simple reason. If you go to any country in the world, in some of the countries, they have unlimited resource with limited population. But in India, we have unlimited population with limited resource. That is a really challenging task for us. You cannot simply conclude that we should decrease the number of hours or increase. Again, it's a difficult process. Then what are the differences? Explicit remote work recognition. Jurisdictions such as Spain and Japan have passed specific remote work laws creating regulatory equivalence between traditional and remote arrangement. But India does not have express statutory recognition of remote work with attendant regulatory gaps. Next, digital disconnection rights. They have in France, Spain, Australia, and Quebec. They have introduced express right to disconnect legislation dealing with digital work incursion, but India does not have statutory recognition of disconnection rights in the face of increasing digital work issues. And when it comes to the working hours flexibility, Australia and the EU utilizes the contextual method of working hours evaluation, striking a balance between employer flexibility and employee protection. Whereas India's hour for hour rigid restrictions are inflexible to various work patterns. It depends upon the work patterns. Then coverage extensiveness, where EU policy sets extensive coverage that cuts across employment status, India's fragmented system omit large workforce section, especially in the unorganized sector, where about 30% to 93% of employees work. Then, when it comes to the enforcement mechanism, countries such as Australia have developed specialized institutions such as the Fair Work Ombudsman to enforce working conditions, whereas India depends on traditional labor inspectors. Where are your labor inspectors? Have you seen them? What is happening in India? See, that can be done in countries like that because again I was telling that unlimited resource with limited population is fine. But what about our country? How to ensure governance to promote and preserve the important rights guaranteed to the worker and party of the constitution? That again, this India regulatory gap arguably erodes the constitution commitment of human conditions of work in contemporary employment relationship. The digital revolution of work necessitates related regulatory transformation with conventional location-based principles increasingly unsuitable for responding to present-day working conditions issue. Whatever I discuss now, I think I have made it clear where the working hours in different countries, minimum 40 hours, maximum 48. But in India, especially in provision under specific legislation, it is there 48 hours. But informally, especially informal sectors like unorganized sectors, they work even security guards, they work 12 plus 12. Unless he comes and gives, he will never leave. He has to be there in the institution or wherever the workplace, he has to be there for 12 hours. If that is the case, how to balance the personal life with this work, workplace, that is another issue. Then I have taken, along with working hours, I have taken another welfare measures regarding maternity benefit. There are series of cases. I just read out. You will be wondering that these are the directions given by the apex court as well as respective high courts of respective states to ensure the maternity benefit leave. But if you just go and ask the private people regarding maternity benefit leave and there will be no justice at all. For example, in the case of Pramila Rawat versus District Judge Lucknow, the Allahabad High Court observed that ad hoc employees entitled to same maternity benefit as other employees. The failure to renew ad hoc rolling contracts solely based on excising maternity rights is not permitted. In Jammu Kashmir High Court, in case of Simi Datta versus State, the claim of a lecturer appointed on ad hoc basis for maternity leave was allowed. The court rejected the position of the state government, holding that distinction had to be made between female employees appointed to the regular basis and those on ad hoc basis. Then another case where in Babulal Joshi versus administrative officer, the court held that leave sanctioned without pay for a worker on the ground that she was not regularly appointed was unjust and payment of maternity benefit was ordered. Why I am quoting all this judgment? This is where you have mentioned Neo-Liberalisation. In this privatization, whether are they really aware about these judgments? Forget about for the workers. Are they aware about these judgments in the employers' concern? Employers. For example, I still remember D.K. Basu case and Paramananda Katara's case, where Supreme Court issued direction. Whenever police want to arrest an individual, They have to follow some guidelines that has to be displayed in all police stations. That is the direction given by the Supreme Court in the case of DK Bus versus State of West Bengal. Similarly, in Paramananda Katara versus Union of India also, the primary duty of the doctor is to administer the medicine to the patient. In the accident case or whichever the cases, when they take the victim into the hospital, generally the doctors, they don't come forward to administer the medicine to the patient. Now we have a Samaritan law which was passed in 2018 after getting assent from the President of India. Similarly, why can't we have a directions? Why can't this direction should be notified in the all industrial establishment or any corporate companies or any workplace or the place of employment? That's another issue. And these are the things we come across to discuss in the working hours of the laborers and work balance. Then another right to disconnect. These three important aspects are there in the neoliberalism, concern. But when we just go through the other part of this, this is the provision we just gone through other countries and what is there in India. But what is the reality nowadays? Especially, this is one part. I just have taken because in the theme I should select one part to tell you something about the working hours. In addition to that, in the neo-liberalization, what are the general problem we facing? Number one, job insecurity, contractualization, poor wages, wage inequality, lack of social security, long and inhuman working hours, gender discrimination, where lower pay is there, unsafe work environment, no maternity benefits, sexual harassment, and very importantly, lack of legal awareness. Nobody knows about the one of the important clause, that is clause E of section 12 of the Legal Service Authority Act 1987. What it says? It is for workman. Workman can have a free legal aid. Who knows this provision? Forget about your PIL and other things. Who knows to invoke section 12 of course, Karnataka State Legal Service Authority and District Legal Service Authority, they have been trying their level best to make known or bringing awareness of all these things to the workman. Who has to fight? And very importantly, NGO can do something. There is a famous quotation by P.N. Bhagavati, former Chief Justice of India, where he mentioned that judge infuses life and blood into the dry skeleton provided by the legislature, create living organism appropriate and adequate to meet the needs of the society. Where I keep adding NGO. Through NGO, judge infuses life and blood into the test. If NGO doesn't come forward to file petition before the Constitution Court, are there any cases where Supreme Court takes suo motu cognizance to ensure the rights of general public? That too, invoking epistolary jurisdiction. I have written an article on epistolary jurisdiction for haves and have-nots, where in 2009 to 2012, they have received almost 60,000 letters, out of which they have considered only 8 to 10 letters. There is a separate cell. If you just go through the Supreme Court website, there is a cell called PIL cell, Public Investigation Cell, where retired judges will be there and they keep scrutinizing all letters sent by the general public, and one or two will be considered. The epistolary jurisdiction, as you all know, it's a part and parcel of the PIL. But other than that, who has to take it? What kind of awareness we need, especially for the laborers? And what is the role and responsibility of labor inspectors? What is the role and responsibilities of NGO? And nowadays, especially in neoliberal, system, the trade union have become very big. What is the role of trade union today? Again, it is politicized. Who has to come and if they go through the trade union, whatever work to be carried out, it never happens. Without trade union, somehow they can get justice. If they approach trade union leader, again, there will be an issue. If this is the state of affairs, how to protect the interest of labor in the neoliberal sector? That is another difficult task. We all have to think. And now, after Ajay Asya versus Khalid Mujib and R. Shiddi versus International Court of Authority, they laid down some of the aspects. If they fulfill this requirement, then they can be brought under the definition of state. Now, privatizing all public services, public utility services, where the employees are working. If it was done by the government, then they can go to the Supreme Court under Article 12. But now, government also very clever. When they privatize all these public services, even they cannot approach Supreme Court under 32 because they don't come under the entity which violates your right, do not come under the definition of Article 12. Again, if I make a statement that in the neoliberal system, all private agencies should be brought under the definition of Article 12, then again, that is not the balancing approach between the private sectors as well as the general public. Somewhere, government interference and mindset of an individual matters, where workers should be aware about their rights. If they really participate in the process, definitely they can get justice. Where it is pertinent to remember one of the statements made by the Lord Montesquieu, who wrote a book on the spirit of law, where he says, democracy works when people are intelligent. Democracy works when people are intelligent. Otherwise, it is worse than tyranny. Democracy demands participation. The quality of participation by the labor depends upon quality of awareness. The quality of awareness depends upon quality of information. If you do not have information, where to go, what to do, where to approach, then the very object enshrined in the constitution as well as in the respective labor-related legislation, it gets defeated. So it is the need of our to think when we enter into the neoliberal system, somewhere state governments have to come forward to look into the interest of laborers in different perspectives. Of course, you have 21, 39 is there, 39 is there, 41 is there. In fact, I wanted to share my own case where my sister-in-law, she is a Panchayat Development Officer. In Karnataka government, those days in 2010 and 11, they used to give only 3 to 4 months maternity benefit. Whereas central government increased from 4 months to 6 months. And also they provided child care leave. My sister-in-law asked the question, why can't we fight this? Why can't we challenge this discrimination? Why there is a glaring discrimination between women who are working in central government and women who are working in state government? Is it not a glaring discrimination? Then, but it is not enforced before the court of law because the providing maternity benefit leave to the pregnant woman under 42 falls under DPSP. 37 says direct principle state policy are not enforced before the court of law. We can't request the court to issue direction to the Karnataka state government to increase from 4 months to 6 months. But nevertheless, we went and approached. Justice Nagmohan Das was judge. In the case of Shakuntala versus State of Karnataka, we filed a writ petition, requested, and 42 have been requested to interpret 42 with that of Article 21. We got favorably, and Justice Nagmohan Das directed the Karnataka state government to increase from 4 months to 6 months. Today, all women in Karnataka are enjoying 6 months maternity benefit leave because of our participation in democratic system by filing writ petition before Honorable High Court of Karnataka. Ultimately, it is our duty to participate in the process to ensure the rights of labor class. So, my final conclusion for this topic, as I told you, whatever directions are there, just in a very simple way, in a vernacular language, it has to be displayed in all establishments, both in Kannada as well as English. When laborers or workmen or employees, whoever, whatever the nomenclature you call, when they see the guidelines, then they can participate in the democratic process. Somewhere, some extent, the rights of the labor can be protected. And finally, I wanted to thank a dynamic principal of this esteemed institution, Professor Mallikarjuna sir. He has a wonderful concern about our ULC, University Law College. And in fact, I was telling from University Law College, sir has invited 3 professors, and we should be grateful to you, sir, for giving me an opportunity to share my views on the workers, hours and work hours and other related issues with respect to labor rights. Thank you. Thanks for your patience.
Thank you, Professor Dr. Sathish Gowda, and for your impactful talk on labor rights and Article 32. Your insights on Labor Day and the move from 60-hour week and the challenges faced by the contract workers shed light on critical issues like job insecurity, lack of social security, low wages, limited maternity benefits, and poor legal awareness. Your comparisons with the right to disconnect in EU and Australia and overwork concerns in Japan offered a valuable perspective on where India stands. We're truly grateful for your presence and thought-provoking reflections. Thank you, sir. I would now request Professor Babu Mathew, sir, to please take the dais. Thank you,
Respected principal of this excellent institution, Professor Aital. I now also see my close friend and colleague S.N. Murthy, a leading practitioner of labor law in Bangalore and Karnataka. They're old friends, and so I'm very happy to be able to share a few thoughts in his company. Yes, I am particularly advantaged today by the presence of Dr. Sathish Gowda. He said that he was not a labor lawyer nor a labor expert, but I think his expertise in constitutional law has sufficiently encouraged him to venture into the most important aspects of labor law. Yes, if you were to ask me what are the issues on which I would like to focus the maximum, I would be in agreement with Dr. Sathish Gowda. I also think that working hours is critically important in the life of all working people, not just the working class, but all working people. And it is those who belong to the informal sector who have the least protection in this regard. And they are the ones whose numbers are overwhelming, as already pointed out. Also, the question on maternity. Be the law as it may, I would subscribe to the value that there should not be a single woman in India who does not get maternity benefit. I think it's at the core of human rights and human values. And he picked up that as the second most important issue. And the question of right to disconnect, I welcome that very much, because from the point of view of gig and platform workers, they are very often asked to wait indefinitely for the next order to reach them. And it is in that context that if they can disconnect, that will be a more just system. And even the European Union and friends in the ILO are thinking on those lines. So this was an extremely valuable talk that we have listened to today. And but I asked myself, did it make my task easier? I doubt. I doubt, because it's difficult not to be redundant. And from that point of view, I'll make a special effort to defocus on some of my favorite things and pick up something which may not be in the nature of a redundant presentation. I look at the question of constitutional mandate to begin with. And I must say, as a sweeping generalization, that when it comes to labor rights, there is a hard conflict going on between constitutional values and neoliberal values. I'm not one who thinks that these two can coexist. Neo-liberalism is marching across the world, except that recently it is considered to be crazy thanks to President Trump. I think he has raised severe doubts on globalization. Not only on globalization, but on its most important element, and that is trade relations. He has done away with the World Trade Organization in practice. And so globalization, in a sense, is under deep challenge. But yet, I wouldn't think that neoliberalism is under deep challenge, because neoliberalism drew its strength from the World Bank, the International Monetary Fund, the Treasury of the United States of America, and from the WTO. So it's only the fourth limb that is relatively paralyzed, and therefore we are going to see more of globalization and of the neoliberal variety. About the Constitution, I think among us it is common talk. Yet I make bold to say a few more things before I proceed further. I think it is important to remember that the Constitution of India is the product of the independence struggle. I think it's not enough to call it the independence struggle, it's a national liberation movement. There have been many national liberation movements across the world, but few of the type that we witnessed in India. Is absolutely unique. I dare say there is no other comparable national liberation movement. The role of armed struggle very often gets mixed up into a national liberation movement, be it the Soviet Union, be it China, be it many of the erstwhile socialist countries. They intellectually subscribe to the idea that violence may become inevitable. But in the case of India, I think the extraordinary example that students should remember is go to the Chowri Chura incident. Chowri Chura is an incident where the whole of the local community rises in rebellion against the policemen, and they decide to burn the police station because they felt that the policemen intervened in favor of the landlords. And what does Gandhiji do? He calls off the independence movement. He calls it off against the opinion of the entire leadership at that time and says nothing doing, and he doesn't budge. And that's a deep value that we got, that if we want to get our independence, it has to be the non-violent path, the path of ahimsa and satyagraha. And that is what makes it absolutely unique. Many great leaders of the world have subsequently tried to understand the significance of that. And I think in that category comes Nelson Mandela. Though he was locked up in solitary confinement for almost 25 years, he would often say that there is a lot to learn from the Indian experience. So that's the reason why we consider that our struggle was an extraordinarily important one. And one more reason that we must note why it became so important is because in the independence struggle, every section of Indian society participated. The peasants participated, the farmers, the workers participated, capitalists participated, especially the national bourgeoisie, ordinary intellectuals and extraordinary intellectuals from the realm of arts and fine arts and theater and poetry and songs, they all participated. The only section which did not participate are the landlord class. And despite their non-participation, we achieved independence. And that's the reason why it's a very powerful movement that we got out of it. Another reason which must be remembered is one of my students, Tarunab Khaitan. He has been doing studies in Oxford on the constitutional history of different countries. It's pointed out that the average life of a constitution after 1789 is the French Revolution. After that, the average life is 17 to 19 years. We must pause to ask ourselves, how come our constitution has crossed the platinum celebration stage? There must be some very unique reasons for it. One unique reason that is given is that the constitution making process was by consensus. Dr. Ambedkar, of course, played an extraordinary role in that regard. And there is hardly any important issue on which consensus was not reached. Doesn't mean that everybody agreed with everything else. but I think the spirit of the independence movement and the stature of Dr. Ambedkar. I want to specially point out to friends who may not be aware, don't mistake Dr. Ambedkar for somebody who became what he is because of the reservation system. Ambedkar was, by his own merit, an extraordinarily brilliant person. You've heard about PhDs. There is a degree after PhD, and that is called Doctor of Law, Doctor of Philosophy, Doctor of Science, and Ambedkar had a collection of all of them. And he was master of several subjects. And so that's the man you should remember when you think of Dr. Ambedkar. And hence his role in the Constituent Assembly was extremely unique. So that kind of a constitution has served such a long period. It is useful, I think, to make that comparison more vivid, more glaring. Kindly look at Pakistan. Pakistan has had how many constitutions? 1956, 1962, 1973, and a provisional order in 1981. Well, Muhammad Ali Jinnah set out to say during the peak of the independence movement that he subscribed to the two-nation theory. And as a result, Pakistan was born because he said the Hindus and the Muslims cannot live together. And so I'm going to form my own Pakistan, which will consist of the Muslims. Pakistan became a Muslim nation. By the way, important to take notice of the fact that being a Muslim nation is slightly different from being an Islamic nation. And Pakistan later on went on to become an Islamic nation also. And so Muhammad Ali Jinnah's theory, fully blossomed. But it's useful for us to ask, what is the net result of that? How was Bangladesh born? If it was the two-nation theory which was the supreme most, then Bangladesh would not have come into being. But we know that during the war against Bangladesh, that's the National Liberation War of Bangladesh, Sheikh Mujibur Rahman, and the role of the Indian government, the role of the Indian army. What a brilliant process of national liberation. There was a huge public support in Bangladesh. And don't forget that 90,000 soldiers of Pakistan were arrested and they had to surrender before the Indian army in Bangladesh. That's a moment of humiliation over which they had never overcome their anger towards India. Of course, I think slowly, unfortunately, that is getting reversed. And the history of Bangladesh is tarnished now, and we must watch carefully what happens. But my remarks are confined in order to say that, the Constitution of India derives its strength from extraordinary circumstances. On this occasion, I cannot forget to remember Dr. Upendra Bakshi, Professor Upendra Bakshi. Bakshi is one who points out that there are 3 transformative constitutions in the world. He refers to the South African Constitution and points out that the reason why it is transformative is the long struggle against apartheid. He then refers to the Brazilian Constitution and says it's the long struggle against authoritarianism. And then, not sequentially, there is the Indian Constitution, which is the product of more than 100 years of independence struggle. That's the reason why these are transformative constitutions. I take so much time in order to dwell on this aspect, partly because of the presence of Dr. Sathish here, and partly because I want to suggest to you that the Indian Constitution's value is being undermined at the moment. As a student of constitutional law, I am very doubtful how much longer this Constitution will survive. I'm seriously in doubt about that. And it's based upon what you and I can observe in Indian society. And so, in the context of looking at labor rights are adequately covered by the Constitution of India. You can pick out more than 20 provisions which have a direct bearing upon labor rights in India. For lack of time, I don't think I will attempt that just now. But I must point out that all those very values come under deep danger when it comes to neoliberalism. Neoliberalism is not something we think to happen in the future. The future constitution we are yet to see. But neoliberalism, you don't have to wait, you can see it. Neo-liberalism came into the world as a result of the collapse of the Soviet Union. And as a result of that, the World Bank, the IMF, the WTO, and the Treasury of the United States of America decided to launch globalization through neoliberalism. So it's neoliberalism that reigns the world. And the question of neoliberalism in India is of particular significance. There are great scholars who have analyzed it, and I want to share that analysis with you. I may have done so in an earlier audience, but I think there are new faces here, and so I'm going to repeat it, and please bear with me for that repetition. And that is, what is neoliberalism? How do we understand it? The best of economists tell us, when there is a balance of payment crisis, India had a severe balance of payment crisis, not enough of foreign exchange to last even for a few weeks. And at that stage, then everybody is looking around what to do, including the Prime Minister of India, Sri P.V. Narasimha Rao. What should be done? The first reaction is to send gold from India abroad. Gold is sent to the UK and to other parts of the world in order to get foreign exchange. That doesn't resolve our problem. And it is very important for you to note, there is an organization at the international level which is waiting to see a country that is in balance of payment crisis. And that is the International Monetary Fund. They wait and they're happy that India is in crisis. And what do? They say, come to us, we will give you the stabilization fund. As many dollars as you want. Whatever India asks for, double that is available in the IMF. But if you want to take the stabilization fund, you must agree to the conditionalities of the IMF. And the conditionalities of the IMF, India had to accept in the form of the structural adjustment program. For that period of time, it must be noted that it's not the Finance Ministry of India which was calling the shots. It was the Treasury of the United States of America. And as a result, we have hook, line, and sinker swallowed the structural adjustment program. Some other countries, Sri Lanka, had a similar package which they used to call as poverty reduction strategy paper. That led to financialization, is a worse form, and here we got into globalization, slightly better, but you know the crisis that Sri Lanka had faced at that time. And now other South Asian countries, Pakistan is the second biggest victim of that. India too is still in difficulty in relation to that dimension. But that aside, and so as a result of this process, we see that structural adjustment was implemented. Topmost item in structural adjustment is privatization. Privatization of a dogmatic variety. Just as during one period of time, there was dogmatic nationalization, there is now dogmatic privatization. I am not a supporter of blanket privatization. Neither am I an opponent of the private sector. And I'll tell you this aspect shortly. But what is this privatization? Why should we be opposed to it? There are many reasons, and I think very little scope for convergence on that. But let me mention to you, my spirits get completely elevated when I think of the performance of the Indian Space Research Organization. We are one of the best in the world. That's not a product of the private sector. I'm happy when I see the Defense Research Development Organization's performance. That is not in the private sector. Abdul Kalam and his missile technology. India is every day marching forward. The latest during the last week, we have invented things through missile technology which can handle issues which many of the leading countries of the world have not yet begun to think about. What about our banks? I know there will be more controversy about banks, but I think the Indian banking system has done brilliantly. And that's the reason why they have been able to expose the method by which non-performing assets have been taken for a ride in this country. How much is it? 14,000 lakh crores of money has been caught into the non-performing assets. And if you get some of that back, you can provide not only maternity benefit for every woman in India, you can provide many welfare measures which are sadly wanting in this country. Instead, that's being written off. A haircut is given to those who have borrowed money. Happily, one of them has I think already been arrested for having looted the Punjab National Bank. But there are many others of bigger stature whose names are not even mentioned just now. And so that is the looting. What is this money that the banks are losing? Is the money of people here. Oh, I'm sure every parent of yours must be having a fixed deposit. Savings bank account apart. That's the money which goes into the banking treasury. And that money is given out to the industrialist as a loan. And he doesn't repay it. Even defaulters, legally they are at default and still they are spared. And so that is the history of bank nationalization. Insurance. I am a supporter of the employee state insurance for the reason that if you give health insurance cover to the private sector, then you don't know what's going to happen. Even the middle class finds it difficult to recover money from that insurance package. Forget the ordinary people. Yet, today's bandwagon is insurance, private insurance for everybody in the health sector. So that's another aspect, and on and on. Similarly, beyond that, beyond privatization is the rules relating to entry of capital and exit of capital, entry of consumer goods, exit of consumer goods, entry of technology. All this is part of the structural adjustment program. Financial sector reform, which in practice means privatize all the banks and the insurance industries. And then if all that is not enough, then make sure that there is flexibility of labor. For this audience, let me mention to you, it's from flexibility of labor and the philosophy behind it that the 4 labor codes have arisen. And they rest on those laurels. And as a result of it, it's simply, what is the simple meaning of flexibility of labor? If you have labor legislation to protect workers, that is rigidity of labor. So the easiest way to achieve flexibility is do away with those labor laws that give some protection to work with. And I think the 4 labor codes must be examined, scrutinized rigorously from that point of view. I'm not one of the followers of the dicta that is pronounced by the central trade unions, because they say we will oppose it on a blanket basis. I'm not in agreement. Of course, they give a reason that since the Indian Labour Conference was not called, we oppose it on a blanket basis. That's a good rationale. I don't quarrel with that rationale. Because in India, whenever there was important labour law reform, the Indian Labour Conference was always called. And this is indeed the most far-reaching labour law reform is the 4 labour codes, and yet the ILC is not come. I'm happy to say a committee headed by Basavaraj Bommai, the Standing Committee of Parliament, has made a recommendation to the Government of India that the next Indian Labour Conference must be called in order to discuss the labour codes. That's going to, if that comes into force, that's going to be a very unique development so far as addressing and understanding the labour codes are concerned. I must not pass off from this subject without mentioning, so that I make my own credentials clear. Are there good provisions in the labour code? I pick up one of them and place it right at the top, and that is to do with freedom of association and collective bargaining. Incidentally, among the core labour standards adopted by the ILO, number 1 is freedom of association and collective bargaining. The Industrial Relations Act gives enough provision for this to be achieved in a manner in which Indian labour law had never achieved. It had never achieved despite the fact that Jajivan Ram, who was the labour minister, moved an amendment immediately after independence under Nehru's regime, and still that amendment to the Trade Union Act was not given effect to, was not brought into force. And what is that amendment? That amendment was a recommendation that you must have collective bargaining, you must have compulsory recognition of trade union. And ever since then until now, it's only in this piece of legislation that that right has been recognized and worked out in fairly interesting detail, including, I'm quite happily surprised that the central rules in this regard recommend a secret ballot for the compulsory recognition of trade union, unlike the government of Karnataka's rules in this regard. That's an interesting contradiction in terms. But let be that as it may, I think you must take note of the fact that once neoliberalism, The unique thing about neoliberalism is neoliberalism here is in practice. And its leading element is the welcoming of multinational corporations and monopoly capital. And when that happens, it comes into contradiction with many things that are in the Constitution. But so far as constitutional law, there are only indications. So far as labor relations are concerned, it's not indications. It's very clearly, it has been enacted as law. The 4 pieces of labor codes are all laws. And so the neoliberal agenda has preceded the constitutional dimension in India. And I think this also must be taken note of because, you heard about, I think Professor referred to it, the Grundnorm. The Grundnorm is an interesting thing when it comes to the thinkers who subscribe to the pure science of law. That's a school of jurisprudence. They tell you don't corrupt law by bringing in any kind of social science in order to interpret it. Okay, you might subscribe to that law, but the moment you reach the Grundnorm, that's the Constitution, then if you want to understand why the Constitution is in crisis, you will have to use the social sciences. And if you use the social sciences in today's context, you'll see that the Grundnorm is in deep crisis. And when that crisis ripens out fully, then the neoliberal practice and the Grundnorm will be converging. And if that convergence happens, then moving to labor rights, I think it will become even more difficult. But fortunately for us, countries like India are unpredictable in many ways. And therefore, I do believe that such a path is not going to be an easy path. I think when, especially the unorganized workers, I have hardly a tear to shed in respect of the organized workers, because they are taken care of in multiple ways. Unfortunately, they constitute only 7% of the total workforce. But so far as the unorganized are concerned, there is a moment when the last straw on the camel's back will begin to act, and that is where you're going to see the real dynamics. May I stop here because I know that another session is about to begin. Thank you for your patient listening.
Professor Babu Mathew for his powerful insights on the Constitution, labor rights, and social justice. He highlighted labor law reforms, the role of labor codes, committees formed to strengthen worker protection. His thoughts on collective bargaining, trade unions, recognition, and the need for flexibility, etc. He contended this to India's constitutional values against global neoliberal pressures. We are truly grateful for his presence and his perspective here today. Thank you very much. Uh, Now the stage is open for questions. I request any of the students who are interested to ask questions, please go ahead. I would request our chairpersons to be please obliged. Yes.
Hello, sir. My name is Jayant Kumacha. My question goes out to Babu Mathew. So you said that you spoke about rigidity of labor because of legislation. Therefore, legislation shouldn't be given that much prevalence. I am of the contrary view. I believe legislation is important for various things such as acknowledgement and giving substantive rights and things like that. But and that theory of it stems from this factor that let's think about market from a laissez-faire perspective. There are markets and markets fail, and then there's government intervention. But beyond this, we have an assumption that government will never fail. But what if government fails? If we give it to the executive and the government fails, then what? Then all we're left with is legislation. Then how do we proceed and how do we reconcile
why 29 pieces of labor legislation have been reduced to 3 labor codes, and on some occasions we can examine each one of those and see whether that adds to flexibility or rigidity. My opinion, it adds to flexibility.
Good morning, Matthew sir. My name is Sathish Gowda. Good afternoon, Matthew sir. So, my question is basically that DPSP can come into the ambit under the SEZ worker, which is skilled and basically the worker who is performing under the specific economic zones. Does they come under the ambit of DPSP's principle and is it can be analyzed with constitutional provision given under that?
Yes, I think SEZs were the forerunners of neoliberalism. So whatever rights existed under old labor law did not sustain itself in the SEZ areas even before neoliberalism. So after neoliberalism, you can imagine what it would be.
Thank you, professors. So we extend our heartfelt thanks to Professor Babu Mathew and Professor Dr. Sathish Gowda for their insightful and inspiring presence in our today's occasion. Your thoughts have added immense value to our understanding in all of the aspects that we have discussed today. I now request Ms. Khushi to please present a token of gratitude and respect from our end to Professor Babu Mathew, sir. I would request Mr. Tanmay sir to please present with a token of gratitude to Mr. Professor Dr. Sathish Gowda. Thank you, sir. I would now, as we proceed towards the valedictory session, I would please request Kusuma to please take over the dais. Thank you.
We commence the valedictory section in the next 2 minutes.